Okay, we'll go to the final matter, which is Myra Keating-Smith versus Hussein Mustafa. And this is number 21 of 2023. Yes, you may proceed. Very well.
May I reserve 5 minutes for rebuttal?
Very well. You may proceed.
The case before us, in essence, is based on both the Superior Court and appellee misrepresenting or disregarding the factual findings and credibility determinations of the magistrate court. Contrary to this court's clear rulings on the matter, in Moore versus Walters, the court ruled Moore's request for us to reconsider the testimony of Walters and her family members, it's outside the province of this court. The magistrate stated, quote, "The court gives credibility to the testimony of the daughter," close quote. This explicit determination of credibility by the magistrate cannot be overturned if a rational person could agree with the assessment of the trial court, as is the case here. This case is before the court because neither the Superior Court nor the appellee ever bothered to defer to the magistrate's determinations of credibility and unilaterally failed to provide any basis by which a rational person could not agree with the magistrate's findings of fact and determinations of credibility. Instead, in its brief, appellees appear to invent a new legal standard, which apparently is called inherently incredible, and applies not to reversing the magistrate's determinations of credibility and facts, but rather somehow applies to the intermediate appellate court's rejection of that it has to be inherently incredible for the magistrate to make a determination of fact. The FED...
Attorney Hodge, if you would try to speak in front of the mic.
I apologize.
I know you have your computer
I apologize.
on the side, but...
I apologize. With respect to the FED court's determinations of facts and credibility, first they determined that the appellee and his son's testimony that they never saw the July 2017 proposed lease amendment under the until the day of trial was not credible. That left the appellant's testimony that she had presented the July 2017 proposed lease amendment to appellee uncontradicted. Second, that the magistrate was accepting the testimony of appellant that she never told appellee and his son that
Attorney Hodge, let me ask you, in your brief, you claim that Mustafa vacated the premises on February 28th of 2021.
Correct.
And was that anywhere else in the record? In the record below that he ever vacated?
I don't believe so, no. But that was not one of the elements that appellee sought a stay of before the Superior Court.
Okay, I understand that, and I think that's also critical. So if he vacated, then wouldn't the case become moot?
If the judgment was vacated, it would become moot.
Well, isn't the FED strictly to regain possession of the premises? And if you regain possession, isn't it a moot case at that point?
Well, in this case, there is a parallel proceeding going on right now. And the
I'm not talking about, this is strictly the FED action that we are talking about.
Right.
And if it was moot, would it be appealable?
Well, that's, as Your Honor indicated, that's not part of the record, technically speaking.
But you've put it on the record before us, and if the trial court the Superior Court didn't have jurisdiction or a moot appeal, then we wouldn't have jurisdiction. And
It wasn't moot when it was filed.
why wasn't it moot when when it was filed?
When the appeal was filed, Your Honor?
Yeah. If you moved out on the 28th of February,
He'd already filed a notice of appeal. It was already pending.
so when he moved out, why didn't you notify the court that he had moved out and there was no need for the appeal? Especially since he didn't seek a stay of the dispossession.
Because he was still seeking reversal of another portion of the decision as well.
Sorry, I didn't get
Because
an
of
answer,
what?
because what?
He was also seeking a reversal of another portion of the decision as well.
You're speaking about the,
The rent that was withheld,
Correct.
but is that part of a FED?
No, not customarily, no.
Can't be. It can be, because for the longest of time, more than 20 years, it have always been that FED is strictly FED, and you could never join any other type of action, particularly an action for debt, with a FED. That's why it's a summary proceeding.
Well, Your Honor, I would say in this case, because of the limited jurisdiction of FED courts and because this could become a repeating problem, it is within the court's discretion to address the legal issue raised by what the Superior Court did in failing to defer to the factual determinations and credibility determinations of the magistrate court in violation of the court's precedent.
I don't think that was the issue. In FED, the only thing is you're seeking to recover the premises. Summary proceeding to recover the premises. And if in fact that the tenant has moved out, then that will make the whole thing moot.
Well,
Whether there are other things that is cognizable for a civil case vis-a-vis an action for debt for past rent due or for damage to the premises or whatever, that should not be part of a FED action at all.
so if I understand Your Honor correctly, what you're proposing is to dismiss this appeal for lack of subject matter jurisdiction and direct the Superior Court to vacate its decision for lack of subject matter jurisdiction?
What would be the result of a moot action
If it's moot here, it was moot in the Superior Court. Right?
you know,
Well-
you didn't argue this
well-
to us, you know, this,
The opposing counsel didn't argue this to us. That's not in their brief. This is something Your Honor is raising now. If it's moot here, and Your Honor is about
matter of
to
fact,
dismiss it.
they did not even respond and acknowledge that he had moved out. It's only one line in your appellate brief that alerted this court that this case may be moot. And, but that would be the result if we simply left it at that this was a moot case, it should not have been appealed, and we would have to,
Not to here and not to the Superior Court.
correct,
So that the Superior Court would vacate its decision as well?
right.
No objection, Your Honor.
We're not telling you that that's what we are doing. We are asking you why you didn't appeal it, why you didn't have it dismissed based on mootness and avoid all of this trouble. No, you've got it here, and you've said that there are other issues that the courts below may need guidance on. So let's address those issues that you've raised.
Very well. Almost out of time then. I think one of the important things to,
Again, if you would try to speak in the mic, I know
I apologize.
you move off to the
I apologize.
side to see your computer, but put your computer in front of the mic, you should be able to.
I apologize.
Okay.
I think the critical thing that shows that the magistrate's decision, a rational person could absolutely come to the same conclusion as this court ruled in Moore versus Walters, was Mustafa's own testimony on direct examination by his own counsel, where she asked, okay, and when it came time to renew the lease, did you ever tell Miss Myra that you wanted to renew this lease? Answer, when the lease expired, Miss Myra and me, because all the time we are seeing each other, I told her the lease expire and we want to renew it. She just say, I writing the lease. When I write it, we will meet and we're going to a notary public and we sign the lease both together and we go there. That is consistent with the magistrate's determination that my clients, an elderly St. John couple owning this property, did not tell him, don't worry, don't need a lease.
How do you know, they're arguing that once the court was presented with a lease that gave Mustafa the right to occupy this premises, that the court should not have inquired any further, and the matter should either have been dismissed or transferred to the civil division. At least you argue that it shouldn't be dismissed, it should be transferred to the civil division.
Well, I can tell you exactly why. Because I apologize.
Just ask me, address that issue that they're saying once the lease is presented, the magistrate court has no more jurisdiction and it has to be either dismissed or transferred.
There are two different documents at issue here. There is the undisputed written lease with its own terms about how it can be amended, its own terms about how it can be renewed. And then you've got a letter, years later, that they are attempting to present as part of the lease, as though now you're trying to interpret two provisions of the same lease. It's not. There is an undisputed lease. They don't deny this is the lease. They don't
I
address.
understand them to be arguing that the magistrate court should not even be looking at the lease to make this determination.
Based on the trial court's ruling, were a tenant under a lease to come in and say, well, Your Honor, I shouldn't be in this court because I have a lease. Based on the court's ruling, is the magistrate and the Superior Court's ruling, is the magistrate then entitled to examine the lease?
Absolutely. When there is an undisputed written lease with its own provisions about how it can be amended, it is not a he said, she said about what the lease says and how it can be amended. You don't get to have a written lease with its express terms that the tenant admits, this is our lease, express terms about how it can be amended and what the renewal provision requires.
Does not the magistrate court have to delve into what the lease contains?
Absolutely, and there's no way the court can have any subject matter jurisdiction if all it takes is the tenant saying, oh, well, yes, this is my written lease. That's my signature. I admit that's our lease. Yes, it says it can't be amended except in this way. Yes, it says it can only be renewed in this way. But the landlord said, never mind. It's this other thing. You actually have a tenancy for the next 100 years for $1. What is, if you can't look into the lease?
You're being asked that.
Attorney Hatch, the crucial question is this, and we go through a whole lot of conundrum. There's a commercial lease between the parties. The lease has expired, and within the language of the lease, term of the lease, the first paragraph of the lease, it says you have an option to renew, but the option to renew is on these conditions. You have to execute this, your option in this particular way. To the extent that that is not done, then we don't have a lease, and thereby become a month-to-month tenant. Right?
Right.
And if there's a month-to-month tenant, all you need is 30 days to ask the person to vacate.
Right.
Now, the whole issue is all of these letters that were sent saying this and saying that and saying the other. I don't see anything here straightforward from the tenant that says, I am hereby exercising my right under the option to renew, and I'm renewing it. And remember now, I have more than 90 days remaining on the lease, the original lease. And therefore, I exercise my option, and I need for us to get together to negotiate a new lease.
Right.
That's all this case is about. and I see a whole lot of conundrum and a whole lot of other things interjecting into it that seems to complicate matters. But it's a simple, straightforward case,
I
as far
agree,
as
Your
I'm
Honor.
concerned.
I agree, Your Honor. And you did point out an important thing there. This is not like Hobby Lobby, or I think that was the name. I think that was the name, where it was one of those renewal provisions where you just need to state your intent to renew and you're renewed.
Okay,
It was,
and one last part. To the extent that there were rent held in escrow and all that sort of thing, to retrieve that rent would have been an action for debt to retrieve that rent. Have nothing to do with the FED action, so that if the lease option was not exercised properly, then we don't have a lease, we go to month-to-month tenancy, and if there is monies for rent held in escrow, then you file a civil case in the Superior Court to get the rent money.
understood, Your Honor.
Done.
Understood,
So
Your Honor.
when you asked earlier, if it's moot and everything is reversed, you understand that the magistrate court's ruling that the money was to be given to your client, that will be reversed as well. So you
I understand.
understand that.
Well, hold on.
Well, hold on.
It's the Superior Court's ruling that would be vacated.
What?
Yeah.
The Superior Court's ruling would be
Right,
vacated.
And you file your suit.
If that's vacated,
Or if Your Honor feels that it should be vacated with the exception of its ruling with respect to the funds in the escrow account,
Sure.
understandable, Your Honor,
Okay,
understandable.
thank you.
But I just wanted to
no,
make
I
sure that,
think-
Sorry,
I
you
think-
said with the did you just say with the exception?
Yeah, I know.
right, that you, because you've all said quite clearly, you can't have the escrowed funds adjudicated by the magistrate. So the portion of the Superior Court's judgment that reversed that, so be it. The
Well, we
rest
don't say it. That is the
vacated
rule
for
of
lack
the
of
court.
subject matter jurisdiction, no objection.
But you understand that the magistrate's ruling that the money, with respect to the monies, was also an erroneous ruling because, that is not part of an FED action. So, anyway.
I understand it
the
would be,
time has
have to
gone
be
over
dealt with in a
almost 7
separate.
minutes. And you
Understood.
reserve 5, so we will hear from you on your rebuttal.
I apologize for going over time.
Thank you, Your Honors. I want to address all of the issues that were raised here, but I would like, I think, for purpose of clarifying what this case is really about, to first address Justice Swan's observations about the lease and how it was renewed, because I think this is extremely important to the underlying case of what happened. A lease is a contract, and the contract contains different provisions regarding how the parties are to do certain things. It's true that the lease had a provision requiring a certain amount of notice to renew. However, the parties to a contract can always agree amongst themselves to waive certain provisions and go ahead and renew anyway. There was nothing that prevented them from doing that. And in this case, that is exactly what happened, and it's in your record. If you look at the letter of February 11th, 2017, which is at page 382.
How many years that letter came after the contract was expired?
It was just a few months, Your Honor.
Oh, but it was
The
after.
expiration would have been at in 2016. This was in 2017. And what's
How is
important,
that to alter what was in the contract before?
because you have to look at what the letter actually says. It says, "Dear Mr. Mustafa, in reviewing the reference lease with regard to the renewal you requested." So this is a letter signed by the landlord telling Mr. Mustafa, "I'm reviewing your renewal request." It doesn't say when that request was made. It doesn't say the request was made too late. It doesn't say the lease
You had
is...
an expired lease.
It doesn't say that. For all we know, the
If it
oral
wasn't
request...
renewed, if it wasn't renewed by a certain date, it expired.
But, Your Honor, the letter makes it clear that there was a renewal request. If the renewal,
But the
even if the...
request does nothing.
It does if the landlord, it does if the landlord.
Doesn't the lease require that there be a meeting to discuss and
No.
rent and have
No.
a new rent established? It doesn't say that?
Your Honor, it's very clear from the communication from the landlord that she acknowledged that there was a renewal request, that she considered to be valid, and this letter was simply confirming the conditions of how the rent would be paid and what the rent would be for the renewal term, which was just at its very beginning. The Superior Court found that the evidence was there was a course of dealing.
In effect, what your argument is, is that that letter trumps the written lease and all of the procedures set forth within the written lease for renewal of the lease?
I'm saying, Your Honor, that the letter is credible evidence signed by the landlord that she had agreed to waive those provisions and was willing to renew the lease. And that alone was enough to take it out of FED jurisdiction. Because remember, the point here is not, would you ultimately agree with the tenant's argument that the parties had agreed to renew the lease and that this letter was evidence of that? The only issue is, was this letter signed by the landlord saying, renewing your lease and setting the rent for the renewal period,
what date?
followed by
What date is the letter?
February 11th, 2017.
All right, the February 11th letter, all right?
And it's at page 382 of the joint appendix.
Yes, all right.
Okay, and the very
I'm looking
first
at it,
words
and,
are in reviewing the reference lease with regard to the renewal you requested. Now, if the landlord was taking the position that the renewal Mr. Mustafa requested was too late, that the lease was already terminated, and that she wasn't going to entertain it, this was the time to say so. She did not. She instead went
Did she say that
ahead.
she extended it?
She said, here is the rent. It tells, the letter sets forth what the rent will be. Lease renewal period, monthly rent payments, March 1, 2016 to February 28, 2021, $11,198.82. And
That's the
this
exact
was,
same amount as had been
as he,
prior.
and then, no, it's not the same amount
Is
as
there an
prior.
increase? Is there an increase?
It's an increase.
Of how much?
It's an
Because
increase
if I
of
follow the evidence,
$140, and it's an increase. It's saying that the monthly rent.
I saw it as the exact same amount, so.
But what she's saying is lease renewal period. In other words, this is a letter, Your Honor, again, we're in an FED.
But you don't know when he asked that. It could have been after.
No, it could have been, but it doesn't matter. The
Why?
point is that, because,
Look,
the point is that the
lease
landlord,
provide a procedure for renewing it.
and the landlord is free to waive that procedure, and this is evidence that she did. And that the argument that she did, and that for the rest of the time, for years, they operate on that procedure. Further evidence that she had waived and considered the lease to have been renewed is the January 8th, 2018 letter, in which she refers to your current lease term and your obligation for insurance and property taxes. Those are not references to somebody who's a month-to-month tenant. And the Superior Court correctly.
The lease also provided if you held on that you would become a month-to-month tenant. So basically.
But that does not
So when you're talking about
say.
your current tenancy, why wouldn't it be a month-to-month?
Because it says, rent starting January in 2018 in the regular monthly amount and continuing for the remainder of the current lease. That is not a statement made to someone who is a month-to-month tenant. And the Superior Court correctly.
Why not?
Because
it would
it is.
continue until it's terminated.
You don't talk about a current lease term with somebody who's a month-to-month tenant. Your Honor, again,
If the
the
lease
point.
provide that you become a month-to-month tenant if you don't renew,
But that is in addition, Your Honor, in addition. The landlord's testimony, which is disputed, that after all these events, at sometime in 2017, she presented an amendment to confirm the lease renewal. If he was a month-to-month tenant, why do that? It's inconsistent. The landlord's position was all over the place. There's a letter that she wrote and signed saying, I'm entertaining your renewal. There's a letter referring to the current lease term. There's a landlord's testimony that she claimed that there was an amendment that he was supposed to sign, which he denied having ever received. All of this was enough.
You said earlier that the minute she came in with this letter, that the magistrate lost jurisdiction.
That is exactly, Your Honor, what the standard is, what the Superior Court
And
found,
what is the basis for that? Because
the February 11th letter
no, I'm asking, what is the basis for concluding that the minute she came in with a letter that was written after termination?
no evidence that there was a termination, Your Honor. The
But
minute
the
there
lease
was,
itself provide what happens if it's not renewed.
unless the parties have agreed otherwise. And clearly, this letter was evidence that the parties had agreed otherwise. In other words, Your Honor.
But my question to you is, why did the magistrate court lose jurisdiction immediately?
Magistrate
And why
court,
couldn't the magistrate court look at that letter, look at the lease, and make a determination whether or not that was in fact some, I don't know.
because that was outside the scope of what an FED court can do. The FED
But that's what
court
I'm asking you to tell me why. Because the only limitation I
requires
see
an
here is
interpretation.
that the court should not inquire into the merits of the title. And you're saying that the lease is the title and therefore.
No, Your Honor.
So what else precludes the magistrate court from
I am
ruling?
saying that the interpretation of the lease combined with the letters presented by the tenant was a rational, bona fide argument that could lead one to conclude that he was a tenant under an unexpired lease. It was some evidence that was not irrational,
And
that
my
the
question
parties
is,
had
why-
agreed to
Why
renew.
couldn't the magistrate make that determination, whether or not it was or was not?
Because once there was something presented that was signed by the landlord and that was evidence of a bona fide dispute, then that took it out of FED. And there's a good reason for that,
But tell me,
Your Honors.
what's the legal authority for that argument?
The legal authority is every decision this court has ever made about the scope of an FED case. The legal authority that the purpose of an FED proceeding, as outlined in our brief, is a very limited remedy that gives the landlord an extraordinary right to avoid the entire civil litigation process with discovery, due process, jury rights, everything else, only when the landlord's entitlement is clear and indisputable. And as soon as there is evidence of some bona fide basis, which is not made out of whole cloth, presented by the tenant to say, hey, the landlord wrote me this letter, I relied on it, she told me when she presented it to me that this was an extension. Every action by the landlord for the next 3 years was consistent with the understanding that the lease had been extended. It wasn't until June of 2020.
I looked at that letter as simply a demand for rent.
I'm sorry?
I looked at that letter and it was simply a demand for rent.
It says with regard to the renewal. It doesn't say I'm not renewing.
I'm
It
saying
says,
that the letter was a demand for rent.
Your Honor, the letter
But what-
refers to
but
the
read
lease
the
renewal
letter.
period.
Other than that one paragraph, with that one sentence, read the letter, and the letter was a request for rent.
No, the letter was a request for solving certain things in connection with the
Right.
renewal. In the total context of the letter was saying, these are the things I want you to do in order for me to renew the lease. And there's no evidence that
So-
those things weren't done.
But see, you're really arguing against yourself.
No, I'm not, Your Honor, because
Attorney.
the Superior Court was absolutely correct
Attorney.
when,
Let me go back to a very simple, forthright question. The question is this. In the commercial lease between the parties, it says that the tenant, provided the tenant is not in default of any of the terms, the tenant shall have an option to renew for an additional 5 years, provided the tenant give landlord or its duly authorized agent written notice of such intention by registered mail not less than 3 months in advance of the expiration of this lease. My question is, did that occur?
Your Honor, as I told you,
Did your
I don't
client
know.
send a registered mail?
I don't
indicating-
know. There is no evidence one way or the other of whether that
Because-
happened. But if you allow me to answer the question, Your Honor, my argument is,
No, no,
And
no,
I
no,
think
no,
this
no,
is-
no,
no,
I'm
no,
not talking
you-
about your argument. I'm talking about whether or not 90 days prior to the expiration of the lease, did the landlord or his duly authorized agent sent a written letter by registered mail exercising the option to renew.
And my answer to you, Your Honor, is that the letter of February 11th, 2017 is evidence that the landlord agreed to waive that requirement, as she had every right to do,
Waive the
and that the
requirement?
parties agreed to a renewal of the lease under
Waive
other
the
terms.
requirement of the
Yes.
lease?
Absolutely. If the
And you-
landlord was taking the position that the lease was
We-
terminated and she
a
wasn't
written
going to
lease and
enter.
somebody can unilaterally waive one of the most important
Your Honor,
provisions
I'm
in
not
the
saying
lease.
that. I'm saying the parties can agree to renew the lease and waive that. And it happens all the time. In the commercial world, leases are extended and renewed all
So
the
are you
time
saying that
when the
other-
parties
are
don't
you
find
saying
it to
that
the
other than
letter.
the commercial lease we have in front of us that was made a part and parcel of the joint appendix, that there's a other commercial lease between the parties?
Your Honor, no. Again, I am saying that this commercial lease, like every commercial lease, if the parties agree to renew, even if the tenant hasn't complied with the 90-day period, they're free to do that. And once they make that agreement and proceed under that agreement, for 4.5 years, the landlord is bound and can't come back 4.5 years later and say, by the way, back in 2016, you didn't give me a letter. So even though I have been treating you like you have a lease extension and I have been writing you letters and I have been accepting your rent payments for 4.5 years, now I've decided you're a month-to-month tenant and I'm kicking you out. That's
But
what I'm saying.
Well,
That's
that's
not-
what
that's-
would occur.
And that is what happened in
But
this
that's what
case.
the lease requires. The lease says
But-
if you stay on, that you become a month-to-month
Tenant.
tenant. So therefore, there was a tenancy, there was
Your Honor,
know.
that is not, the lease required a certain provision for renewal, and the landlord always had the right to accept renewal orally or any other way if the landlord so chose. And the February 11, 2017 letter clearly shows, is clearly evidence that that is exactly what the landlord did.
That's why you have a lease.
So-
Both parties must.
You can always
have
change
the
a lease, Your Honor. That is the whole point. And the fact that we're
And if
having
you-
this
and-
debate,
and if
the
you
fact
did
that the
exercise
Superior
your
Court
option
judge,
according to the commercial lease, then you don't have a lease, and the lease.
unless
says
the landlord
then
agrees
you go to a
otherwise,
month-to-month tenant.
unless the landlord agrees to waive that, which is what she did. The landlord can always say, you know what, tenant, you didn't give me notice 90 days before, but you're a good
That
tenant.
wasn't done in this case, though.
But it was. She was considering his renewal. And then later on, she claimed, even though this is disputed, that she actually presented him with a renewal paper. She claims he didn't sign it. He claims he never got it. But
By way
clearly,
of a letter in which the landlord say, Mr. Mustafa, I am hereby waiving my rights under the commercial lease. between the
saying,
parties."
with regard to the renewal you requested, she is not saying, I am denying it.
No.
She is not saying that. She is saying with regard to the renewal you requested.
In reviewing the reference lease with regard to the renewal that you requested, but she doesn't say how it was requested. And I go back to my fundamental question, was the option exercise consistent with the language of the lease? And then she goes on to say, we discover several inconsistencies in a monthly payment of rent received versus the monthly payment of rent stipulated in the reference lease.
Exactly.
But which reference lease are we talking about?
We're talking, yes, but exactly, Your Honor. And then the parties sat down together, and this is undisputed, and they met and they went over this letter, and they made some corrections on it, and reached an agreement. And they reached an agreement on dealing with all these issues
That's an
and on the
evi-
rent
that's an-
for the
that's an
renewal
evidence?
term.
And
I'm sorry?
That's an evidence, this marked
That
up
was
letter?
Mr. Mustafa's testimony backed
Oh.
by this letter. And that
And the
was,
opposing testimony was that,
right, and that was enough to create the bona fide dispute. Remember, Your Honor, an FED proceeding, which is done with no discovery, no right to any document request beforehand. The amendment document was never presented until the middle of the hearing. All of this is a special right given to landlords to allow them to bypass ordinary civil
yeah,
proceedings,
without
only
using-
when
without
there's
using
no
self-help
argument.
like they had before.
Right, and this was sufficient. The Superior Court looked at the same evidence and had no trouble concluding that this was sufficient to show that there was a bona fide dispute. And if I might, Your Honor, this case is very similar to the Crown Bay Marina versus Gourmet Gallery case, in which Judge Francois looked at a very similar issue, except in that case, the magistrate's court had dismissed the FED, and the landlord was complaining. And what Judge Francois said, Crown Bay asserts dismissal resulted from the magistrate's apparent acceptance of defendant's contrived misinterpretation of the lease. Crown Bay misunderstands the colorable defense standard and the magistrate judge's role. The record does not demonstrate that the magistrate judge agreed with or adopted Gourmet Gallery's reading of the lease. Instead, the magistrate judge found that the defendant raised a colorable defense which required construction of the lease. The magistrate judge, within the limited scope of an FED action, did not construe the lease for or against either party. That is what should have happened here. Judge Francois was right. Judge Tejo was right. The tenant raised a colorable defense, and this case should not have proceeded. I wanted, Your Honor, to address the mootness argument. I know I'm out of time. I was responding to the court, but I think it's important to understand that that wasn't raised, and that the reason why it's not moot is that there were findings that were going to have an impact on the pending civil action between the parties over damages for what happened both before and after.
You're saying in a FED action that all of those things, the dispute over civil damages, is part of a FED?
No. What I'm saying, Your Honor, is that the FED court's findings would have had an impact on certain liability issues in the other case, and the FED court exceeded its jurisdiction not only by ordering rents to be turned over, which all of Your Honors have recognized it had no authority to do, but also by sua sponte raising and applying the statute of frauds and making rulings on that. Those findings, which were clearly outside the scope of FED jurisdiction, could not be allowed to stand. And I would ask Your Honors to please take a look carefully at the Superior Court's opinion and at what we are talking about here. Landlords have an enormous advantage in the commercial and residential world, and giving them the right to a summary proceeding gives them an extraordinary additional amount of leverage against tenants. To raise the standard for a tenant.
The right that you are saying is they only have a right to file an action, and if anybody comes in and raises some issue, that then they lose jurisdiction. So
I'm saying they have to meet, it's a low bar, but they have to meet the bar. And I am saying, Your Honor, that in this case, Mr. Mustafa met that low bar. He didn't just come in and just give his own oral testimony with no support. He had documents signed by the landlord. He had testimony of other witnesses. He had credible arguments that there had been an agreement to waive the strict requirement of the 90-day written letter and renew the lease. And he was entitled to have those arguments considered in a full, normal civil proceeding, not in a summary proceeding where he had no rights to discovery and was allowed to had to deal with surprise evidence.
The only appeal that we're dealing with is the FED action.
That is absolutely right, and the FED action exceeded its scope of its jurisdiction in a vast and unprecedented way, and the reversal needs to stand.
Thank you.
Your Honors, I'd just like to start out by saying I addressed the specific point that opposing counsel didn't argue waiver in the FED court, in the Superior Court, or in its appellee brief. I pointed that out in my reply brief, that any argument that there were provisions of the lease that were waived by the landlord was not raised, and therefore that argument itself is now waived. This is the first you're hearing about a waiver argument. The term waiver didn't come up about anything except for whether or not I waived a defense of the FED court making reference to the statute of frauds, which is not the basis for my argument in any event. But that's the only time you're going to see the word waive at any point prior to a moment ago. So it's already waived. The waiver argument is waived. As for Gourmet Gallery, That was dealing with the court dealing with two conflicting provisions in the same lease. And the court, even so, had to say, are these two reasonable interpretations of the lease? I can't decide this. Yes, they're both a reasonable interpretation, and therefore I can't adjudicate which is right. Take it to civil court. That's what the rule is supposed to be. Just like if there was no written lease and it was only a verbal agreement, so it's a he said, she said, you can't really get that done if their verbal description of what their lease agreement says is inconsistent, and one says still have a right to possession and the other says terminated, civil division. That's not the situation here. You've got an undisputed written lease. They don't deny it. They're not addressing any provision of the lease. They're carefully omitting mention of all these. Your Honor tried valiantly to get them to acknowledge that the lease says it is 90 days before the expiration date, you need to send a written request for an intent to renew that triggers a deadline to negotiate your new terms. When opposing counsel said that the letter was a few months later, 11 and a half months later, just to be clear. It was 11 and a half months later. Lease expired February, 2016, letter February 2017. The other thing is, well, you know what? I believe I've already hit the nail on the head here. The letter was not part of the lease. You don't get to take a lease that's expired and then say, after the fact, its terms were amended in a manner inconsistent with the terms of the undisputed written lease. Otherwise...
Okay, but what about her argument that once there is a bona fide dispute, that the magistrate court should not decide it and it should be dismissed and let it proceed in a civil case? We have actually had cases that seem to require that, so why shouldn't that be applied here?
There are two standards.
And there was a lease presented and it was a letter saying, look, it was continued on and all these rents. Why didn't that create a reasonable dispute as to a material fact?
Because it wasn't...
Under the procedures that the courts have been using, and this court apparently has endorsed, why shouldn't have the magistrate court dismissed it or transfer it, I guess?
Because if two things here.
Under the case law that we have now, isn't that what normally happens? And isn't that what the case law seems to imply, that when there is, in fact,
at times,
a bona fide dispute that is going to require, discovery, further inquiry, that is not a proper FED matter for the FED court?
At times, the courts have used two different standards interchangeably that shouldn't be used interchangeably. The facially bona fide and good faith standard and the colorable claim standard. And the Hobby Lobby, I hope I'm not, Hubbly Bubbly, which is attached to my original brief, which is a decision by an FED judge, emphasize the distinction between the two. If you've got a written lease, you shouldn't be using the facially bona fide and good faith standard, because it doesn't matter whether you believed you complied with the undisputed written lease. Your subjective belief as to whether or not you still have a right to stay there is not the relevant standard. The relevant standard is whether or not you've presented a colorable claim to the right of possession. And if you've got an undisputed written lease with its own express terms about how the renewal is supposed to be exercised, and as Your Honor noted, the letter they're relying on so heavily, opposing counsel is very carefully taking the first phrase of the opening sentence, ignoring the rest of the sentence, ignoring the rest of the page, ignoring half of the remainder of the page, it said renewal up here, and at the bottom it said pay the money you owe. In his testimony, he admitted that he started making payments, $500 a month. In his testimony, he said he stopped making payments after the hurricanes and never continued. There are thousands of dollars in that agreement, theoretical agreement in the February 2017 letter that he testified under oath he didn't comply with. So the question is it a colorable claim? Not whether it's facially bona fide and good faith. And as I argued in my reply brief, because they didn't address my argument about, based on Hubbly Bubbly, that it is the colorable claim standard that should apply when you have an undisputed written lease, they have waived the right to make an argument on that point, which is the applicable standard. And I do believe that if you don't apply this standard, if you invite that sort of subjective thing, it doesn't matter if it's a letter. It could be, she told me the lease was amended, and now the term says another 10 years, $500 less a month in rent, and I no longer have to pay insurance. That's what she told me. I swear. My son says the same.
Yeah.
Now you've got a disputed issue.
I read a testimony, and my reaction to it was, why is it that parties having a written lease that expressly and explicitly states the term of the lease, if you're going to exercise your option for another 5 years, what you have to do with specificity, and if in fact that you don't exercise it within the 90 days prior to the expiration of the lease, then you will be, that should be the negotiating period.
Right.
This is what the lease said. This is what I understand it to say. The 90 days, once you give me that lease, once you give me that letter, registered mail that you're going to exercise your option during that negotiation, XYZ is the rent. But if you don't do that, then you automatically becomes a month-to-month tenant. All this gobbledygook and all this conundrum that, well, the letter was sent and we shook hands and we are all family, we treated each other by family as if we are family, and we got a lot of conversation going back and forth. This and the statute of fraud is very clear. You're looking for a 5-year lease, then give me something in writing, signed by the parties to be charged. And that's what is good commercial lawyering. But this thing about, and then she did give him a rebate for the hurricane. During the hurricane, she suspended that, all that kind of gratuity. But it still hurdles back, Harold, back to, did you follow the terms of the written lease? If you follow the terms of the written lease, then you have no problems. All this about creating a colorable aspect or a colorable basis for saying in there, or a colorable claim, and all these sort of things, seems to ignore what the parties have signed off on. And what was the lease between the parties, the written lease between the parties? That's why you have written leases. You have written leases so that the people will know what the rights and liabilities are, and so that they must follow it.
And Mr. Mustafa himself, in testimony when under direct examination by his own counsel, testified that she told me, I'm drafting a lease. Gonna have to take it down and get it signed in front of a notary, which is consistent.
Oral and parole evidence and all this sort of thing coming in, trying to change the terms and conditions of a written lease.
Well, I'm not talking about, I'm saying about how do you then, what do you do when the lease is expired? You make a new lease, which is what she was doing. And she presented it in court. The opposing party claimed he'd never seen it till that day. The judge didn't find that persuasive. Rather, the magistrate judge didn't find that persuasive, and his determination of credibility controls. And it's understandable, very rational for him to have believed so, because he testified, Mustafa testified, that she said, I'm drafting a lease. We're going to have to get it signed in front of a notary. That's not that letter.
Okay, thank you.
Thank you.
The matter will be submitted.
Thank you.
We're going to be on excuse.